All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access on our civil docket, both in the courtroom and also online. And up next, we have a motion in the matter of Moran v. Bishop, file 24-9092NZ. Counsel, you want to state your appearances beginning with plaintiff?
Good afternoon, Your Honor. Sandy Jasinski, appearing on behalf of plaintiffs Thomas Moran and Moran Iron Works.
Okay, good afternoon.
Good afternoon, Your Honor. Adam Flory, Smith Boville, PC, appearing on behalf of the defendants.
All right, good afternoon, Mr. Flory. All right, this is a motion for sanctions for alleged spoliation of evidence or, in the alternative, failure to comply with a discovery order. I have had an opportunity to review the motion and brief in support to the exhibits and the motion in brief in opposition. Or I'm sorry, the response and brief in opposition to the motion. Ms. Jasinski, you want to go ahead and argue the motion?
Yes, Your Honor, thank you. As a preliminary matter, I would note that I was somewhat surprised by I believe it is footnote 2 in Mr. Flory's response, where he commented that he had not had because of his client's limited means, and we can certainly debate that, but because of his client's limited means, he hadn't had an opportunity to obtain the deposition transcripts of Mr. and Mrs. Bishop. Those were attached as exhibits to the motion, Your Honor, as Exhibit 7 and Exhibit 8. So Mr. Flory actually has had copies of those transcripts. They were provided in their entirety, not only to this court, but they were emailed to Mr. Flory and mailed to him as well.
Well, I guess he owes you a little bit of thanks then, since you got him for no fee.
Full service, Your Honor, full service,
Right.
Absolutely. Ironically, Your Honor, today is the 16-month anniversary of when defendants decided they wanted to play stupid games. On that date, Mr. Bishop falsely accused Tom Moran and Moran Iron Works of flying in illegals to work at Moran Iron Works, the metal fabrication company that he founded and owns and operates in Onaway, Michigan. Those accusations are false. They accused Mr. Moran and Moran Iron Works of violating a federal statute regarding hiring people who are not naturalized citizens or citizens of the company without complying with federal law. They essentially, Mr. Bishop accused Mr. Moran and Moran Iron Works of a felony. And indeed, in the transcripts that we've provided to the court previously, not only on September 12 did he falsely accuse with malice and recklessly Mr. Moran and Moran Iron Works of violating federal law. He also urged the local law enforcement officer, the sheriff in Presque Isle County, to arrest Mr. Moran as a result of that. These statements were broadcast on WCHY, which is a station that is owned by Mrs. Bishop, Mr. Bishop's wife. There was a letter that was sent on September 20 to Mr. Bishop demanding a retraction and giving him until the 30th to retract and advising if that wasn't done that he would be sued. There was silence in response to that letter. But Mr. Bishop couldn't restrain himself, nor has he been able to restrain himself from shooting his mouth off about Tom Moran and Moran Iron Works since September 12th. On October 4, a retraction letter was sent to WCHY, and Michigan Broadcasters, the LLC that is owned, again, the sole member of which is Mrs. Bishop. As we noted in the motion that we filed, according to her deposition testimony, Mrs. Bishop apparently appears to be a member on paper only, and the operation of the stations are her husband's. He is the station manager. She never looks at the email. She claims in her deposition she never saw the demand for retraction. Nevertheless, that demand for retraction did prompt some action on the part of Mr. Bishop, who decided that he would, on October 7th, try to make a retraction. Those broadcasts, Your Honor, on the 12th, there was one on the 25th, and certainly on November 4, those broadcasts and the transcriptions of them are the subject of requests for admissions that were sent to defendants in terms of having them acknowledge that those are authentic transcripts, that those words were said. And the court may recall that on October 13th, they're playing fast and loose and the responses to the request for admissions were deemed by this court, defendants' responses were deemed by this court to be inadequate, and they were deemed to have admitted the truth and authenticity of those statements. On November 5, litigation hold and preservation letter was sent to Mr. Bishop, and arguably, Your Honor, that's belt and suspenders.
Sure. So that gets to, like, some of the text messages appear to have been, if we take Mr. Bishop's testimony at its face value, would have been deleted prior to the hold letter. But as I understand the law of spoliation, the obligation to preserve may have arisen prior to that.
Absolutely.
Do you want to articulate when you think the obligation to preserve arose in this case, and whether that obligation extends to the corporate defendant to the extent that they can be held liable for the individual defendant's spoliation?
I would argue that the obligation apart from the case law, the obligation first arose when the letter for retraction was sent to Mr. Bishop on the 20th, because it said litigation will ensue if an appropriate retraction is not made. In terms of the obligation of the corporation, Mrs. Bishop made it clear in her own testimony that, hey, I don't look at the company's email. Mr. Bishop does that. That's what he does. And the other thing, Your Honor, to keep in mind is that we have testimony in the bankruptcy court litigation, and those transcripts have been previously provided to this court in the context of other motions. What the cell phone that Mr. Bishop uses in connection with his life, both personally and professionally, has to be paid for by the company, because Mr. Bishop testified that his sole source of income are Social Security benefits that he has been receiving, and he uses those funds to buy gas for his vehicles and basically, snacks at gas stations or meals at gas stations when he's driving around. Records that we also have from Michigan Broadcaster shows that they are paying for Mr. Bishop's cell phone. So the company has delegated to Mrs. Bishop, has delegated responsibility for the company's operations to Mr. Bishop. They pay for Mr. Bishop's cell phone. They are responsible, and they were specifically sent a letter stating that demanding a retraction, which certainly would have put them on notice by that day. But before then, I would submit, Your Honor, and based on testimony that we've derived so far, it's not an issue for the court right now, but it's going to be. That corporate veil of Michigan broadcasters will ultimately be pierced. It's the alter ego of Randy Bishop. Now, in any event, Mr. Bishop testifies, well, I just routinely, at the end of every day, I just delete all my text messages. And he was doing so even after having received the retraction letter. And there are exhibits, or there are requests for admissions that reflect transcripts of particular broadcasts that he specifically refers to text messages that he has been receiving from listeners in response to the Moran lawsuit. And again, Your Honor, he can't shut up about it. As at the last hearing on October 13th, one of the items that I wanted to provide to the court, and the court wasn't really interested in it at that time, and I understand that, were postings and face sheets for a Give, Send, Go campaign that Mrs. Bishop began to raise monies for a legal defense. She started that in April 24, 2025. The goal was to raise initially $25,000, and there are a number of acknowledgments that were made. Thank you so much for contributions. The last I saw, I think they lowered the demand to $10,000. But Mr. Bishop, during his broadcasts, and there are a number of them that we have identified, certainly not all of them, but at one point in September and October, Mr. Bishop at one point said, I'm literally going to be asking you every day to contribute to this legal defense fund. Text me and I'll give you the information. He was congratulating on air or referring on air to text messages that he had received that he deleted, and certainly after September 20 of 2024. And the other thing, Your Honor, and it's not only the text messages that we're talking about here. When you look at what the request for production was, and it's submitted to the court. The request for production refers to all communications with audience members. And as I'm fumbling around here, Your Honor, looking for that particular document.
Well, but how would that be? I mean, we have, the court's already ruled by default as to liability
Yes.
and we're at damages. So I understand, tell me if I'm understanding your argument right about why these texts are relevant to the exemplary damages. Because Mr. Bishop is saying on a broadcast, I've got people texting me this information.
Mm-hmm.
Therefore, he may argue to a jury that, you know, I'm just repeating what somebody showed so that therefore, you know, his intent in doing that would be relevant even as to the measure of damages. And you're entitled to find out, is he lying when he says he has those text messages? Or if he's telling the truth, are they from a source that should reasonably have been considered reliable or not? Am I understanding that right?
That is correct, Your Honor.
All right. So, but communications he would have with audience members about, you know, contributing to his legal defense, although the deletion of those texts would be a violation, the remedy's got to be pretty carefully drawn. How would those texts be relevant to any issue to be tried?
Because what Mr. Bishop also said in those on-air statements was, text me the information, or text me, I'll send you a link and give you the facts. So what he was doing would be continuing, we don't know, for example, what facts that he was sharing with that particular audience member.
Continuing to make defamatory statements.
Continuing to make defamatory statements.
Okay.
Continuing to make defamatory statements, exactly.
That helps me understand.
Okay. In terms of the request for production, Your Honor, actually, when you look at request for production number 1, from September 1, 2024 through the present, all communications between defendant Michigan Broadcasters LLC, defendant Bishop, and purported audience members of your defending fathers, including but not limited to text messages sent to either defendant regarding Thomas Moran. Now, as I noted, Your Honor, there are examples, even after the litigation, that we provided in the context of the request to admit, where it is clear that after the institution of the lawsuit, it is clear that after the litigation hold letters were sent out, that Mr. Bishop was, again, shooting his mouth off about Tom Moran, and those were being broadcast over the airwaves of WCHY. He doesn't identify any of the broadcasts, and we know from what he stated, I believe it was in September and October, that there was at least one broadcast where he stated that I am going to be, you know, seeking money. You're sending me, talking about this lawsuit every day. If I don't get the money for my legal defense fund, we're going to have to go off the air. What did he receive? What did he receive? At one point in September, he refers to two $500 money orders that had been sent to him by some guy in the text exchange that they had, and he's so grateful about it. What did he receive and what did he say? Was it additional defamation that he was providing? So we have no text messages. We have no identification of the broadcast referring to Thomas Moran. We do know of one that was, frankly, loads of fun for me, Your Honor, being referred to as an evildoer. And I had to remind counsel that there are 3 attorneys in the state of Michigan with the last name of Jasinski. One of them is Kathy Jasinski, who I've met once in my life. We get confused all the time. We graduated from law school at about the same time. If you were to Google pictures of us, we kind of look the same. And I had to be very clear with opposing counsel. Please, if you're going to make reference to the evildoer Jasinski, make sure it's Sandy Jasinski and not Kathy Jasinski, because I want to get all the glory for being called an evildoer by trucker Randy Bishop. So we have, it's been an ongoing situation in this court and in bankruptcy court, and we've provided the court with that evidence. Defendants in this case don't believe the court rules apply to them. They don't believe that court orders, whether it is issued by a bankruptcy court or by this court, apply to them. They play by their own rules. We are not required to accept Randy Bishop's word that, oh, gee, I just routinely delete these messages because none of them have anything to do with Tom Moran. The requests for admissions and their responses themselves, without having to go through and dig through all of his other broadcasts, which are archived, those documents show that Mr. Bishop has received texts. He did receive texts. He did receive the litigation hold letter. He certainly received the retraction letter, and he and his wife did absolutely nothing to preserve evidence. This, Your Honor, and this court is not their first rodeo with the judicial system. You take, putting aside for a moment that they share, 3 divorce lawsuits between them before they got married, Mr. Bishop has gone through 2 bankruptcy filings. There are election law claims that they have filed, and there are multiple lawsuits that were filed against Mr. Bishop and his wife for unpaid debts.
Right.
They know how the system works.
That's a
They
little
know what their
far
obligation
afield.
is to preserve evidence. They didn't.
Can I ask you a question about remedy? As I look at the model civil and jury instructions for failing to produce evidence, might or might not particularly fit. It seems to me, though, if I were to rule in your favor that the defendants did fail to preserve evidence with no reasonable excuse and that is relevant to you, number one, that would be limited to any text messages after, on or after September 20th with the
Correct.
hold letter. But also then, if we actually get to, which hopefully we will soon, to a trial, that then there'd have to be something laid out specifically by you in terms of a requested special instruction to tell the jury the defendants failed to produce the text messages they referred to in the broadcast on X and such date. That you may infer, or that I would instruct them, there is no reasonable basis that they have failed to produce those text messages. You may infer that they are adverse to them.
You may infer that they're adverse or that they simply don't exist, and he was lying.
Yes.
And he was lying.
Right, which is why the model instruction may not fit. But you'll have to identify at some point, like precisely which text messages and which broadcasts you're talking about, right?
And therein lies the rub, because the first request for production of documents said all communications to audience members, which means they're broadcasts. Your Honor, again, we have occasionally there's information that we receive that we might want to listen to a broadcast on a particular date. So for example, there are broadcasts that Mr. Bishop in September and October where he was pleading for funds and text me if you need the information and I'll give you the facts. He broadcasts 3 hours a day, Monday through Friday. And the amount of time that would be necessary for the plaintiff to go through all of those broadcasts and identify each one is mind-blowing. It's their obligation because we asked for it. Certainly, they cannot take the position by just focusing on text messages. First, they want you to accept that, oh, there are no text messages. Well, we know that's wrong just from the text messages we did find, because he refers to them all the time. And if you listen to Mr. Bishop's program for any amount of time, and unfortunately I have done so, if you listen to it for any amount of time, he is constantly referring to, I'm getting a text from Gary, or I'm getting a text from so-and-so about this. And in fact, Your Honor, in this case, in the Moran case, when he's talking about the defamatory statement that's on September 12th, he refers to a particular listener by name.
Right. So it seems like the most that I would be able to do today would be to rule that the defendants did improperly spoliate evidence.
Yes.
And that then you are entitled to a remedy, and that whether the remedy includes your attorney fees, but beside that even if I were to rule that you're entitled to an adverse jury instruction, the precise wording and parameters of that jury instruction would be left for a later day.
I think you are right, Your Honor. I would agree with you on that.
Okay, so that when it gets time to propose to submitting jury instructions, I would have ruled that you're entitled to a spoliation jury instruction. You would submit a special jury instruction. Mr. Flory could submit one that he thinks comports with the court's ruling, but is a better example, or he could object to it, and we'd have to sort that out. Is that right?
Correct.
All right. All right. What about your request for fees for this? What are you pressing about that?
It's seriously, Your Honor, we've had to, it's been such a battle in terms of discovery here. It has been a battle to get a proper answer to the original complaint that was filed. It is a battle to get these folks to be deposed. It is a battle to get them to answer any kind of discovery request, and they still haven't fully answered the discovery request here. Identify the broadcast. They have not done that. So we would ask that we, for an order that we are entitled to the attorney's fees that are generated in connection with this spoliation motion and an amount to be taxed, and that would include my attendance here at the hearing today.
So then procedurally, if I were to grant that relief, and I haven't heard from Mr. Flory yet, but if I were to grant that relief, it would be saying you're entitled to that relief, then you would submit a bill of costs to Mr. Flory. He would have an opportunity to object either to the amount of the hours or the amount of the hourly rate.
Correct.
And if he does, then we would have a hearing.
That's exactly what happened in bankruptcy court when Mrs. Bishop was held in contempt for violating that court's order. So yes, that's what I would envision the process would be.
All right, thank you. Anything that I need to know more to understand your argument?
No, Your Honor. I will ask any or answer any questions you have after Mr. Flory's presentation, but that's the relief that we're seeking. Thank you.
Right, thank you. Mr. Flory, your response, sir?
Thank you, Your Honor. Your Honor, initially, I would note that I'm going to circumscribe my presentation to a much higher degree than Ms. Jasinski. A significant amount of what was just veered to the court was completely irrelevant to this motion. Ms. Jasinski talked about litigation my clients had been in decades ago. She talked about things that happened months ago in this litigation. It's just entirely irrelevant. So, Your Honor, I'll just state we don't agree with it.
In the 53rd Circuit Court of Michigan, a heated legal battle unfolded in the case of Moran v. Bishop, where the plaintiff accused radio host Randy Bishop of destroying critical evidence after allegedly defaming Thomas Moran and Moran Ion Works on air. The dispute centered around inflammatory broadcasts in which Bishop claimed Moran was committing serious crimes, including illegally hiring workers, accusations the plaintiff argued were completely false and damaging. After being warned through a retraction letter and later a litigation hold letter, Bishop was legally required to preserve evidence related to the case. However, testimony revealed that he continued deleting text messages daily, even while publicly claiming during broadcasts that listeners were texting him information and witnesses who could support his accusations. The plaintiff's attorney argued this was a deliberate attempt to hide evidence that could prove the broadcasts were reckless or malicious. Defense counsel insisted no relevant messages existed and that Bishop's on-air statements might have an exaggeration or radio hyperbole, but the judge was unconvinced. After examining the contradictions between Bishop's public statements and his sworn testimony, the court ruled that the conduct amounted to clear spoliation of evidence, meaning evidence was intentionally destroyed to keep it from the opposing party. As a result, the judge granted the plaintiff's motion, ordering that a future jury will receive an adverse inference instruction, allowing jurors to assume the deleted messages would have been harmful to Bishop's defense. The court also ordered Bishop to pay the plaintiff's attorney fees for bringing the motion, criticizing the defense for repeatedly making the litigation unnecessarily difficult and failing to follow proper legal obligations. The ruling dramatically strengthened the plaintiff's position as the case moves toward trial on damages, leaving the defendants facing not only the consequences of defamation claims but also the serious legal fallout from destroying evidence during an active lawsuit.